Hello, it's Tyler again. I wanted to talk a little bit more about the Heppner case in a previous video that I was going into detail about, and talk a little bit more about its impact on potential clients or potential litigants and the way we use AI. So some of the rulings from the court in that case kind of touched on 3 points in how using AI was not protected by the attorney-client privilege. And that boiled down to one, the AI is not an attorney, right? And it was not a communication between a client and his or her attorney. And lastly, that by putting the information into the AI system, it was therefore not confidential because you're sharing it with the system. And we know that this data is used by those systems and for a whole host of information. So while there are certainly criticisms, we do use tools in other ways to help in legal matters, and clients without a lawyer may be wanting to get that information. What is really important to know is that if you're using these AI systems without the guidance of an attorney, it can be almost like you're talking to a friend in a way. The way that New York court categorized the use of AI treated it more like a cyborg person than a inanimate tool. So that is a very important distinction, and one that I could imagine be challenged. But again, until there is more guidance or rules coming throughout the country as to how we'll treat these AI systems, for now, there should be caution in that when you're sharing information with AI, recognize that you are putting it into a database. It could be discoverable, and it is not within the confines of talking to your attorney, so it could be treated differently.